Hi, I'm Brian Scarpelli. I'm Senior Global Policy Counsel with ACT, the App Association's Connected Health Initiative, a multi-stakeholder pro-digital health legal and policy advocacy organization, that is. And, this event here today, pretty excited about, very timely, hopefully it's helpful in a number of ways to you all. But we're all part of this wider digital health community. You get emails from us with this bracketed header that says Telehealth Remote Monitoring Coalition, and that's just kind of a default name that somehow emerged over time. But there's no official name or dues or anything like that. It's really just a big old community, big giant community that we share information on as timely developments and ways for folks to make their voice heard on digital health, and then also organize important educational briefings and discussions. And this is a great example of that. The purpose here today is to talk about a new privacy and data security regime, I guess I'll call it. The California Privacy Rights Act, Cpra. I realize that sounds a little familiar. People probably are a little bit more familiar with the California Consumer Privacy Act, which became effective only earlier this year and addressed a range of online privacy protections for California citizens. The Cpra, as you'll hear in a second, I'm sure, is something of a red line and an update to the Ccpa, and while even if you're focused on, for folks who are still joining, I see the numbers going up, which is great. Hi everyone. But even if you're primarily focused on the federal level for privacy, generally or specific to digital health, as my colleague Graham was just talking about on a podcast that the App Association published, latest episode of just yesterday, I think that the prospects of sweeping federal preemptive legislation are probably rather slim in the near term. Who knows? That could change. But and so we see states like California essentially pushing forward and reframing things. So it should be of interest, at least in that respect, but also because it probably really does affect you, your company, your members of your association, your stakeholders, no matter who you are, and love it or hate it, right? So the goal here, I should mention very quick here, that's kind of the purpose of the webinar. It's why we're here. I'll introduce you, Eric, in just a second, for folks who are not familiar with Eric Goldman. But one thing to just mention here, obviously this is a Zoom webinar. If you're not familiar with it, there's a Q&A function. If you hover your mouse anywhere on the screen you're viewing, you'll see a little bar across the bottom: mutes, video, participants, Q&A, chat. The Q&A function allows you to submit questions, and we'll be keeping track of those, and Eric can also see them, and so in that way, if you have one during his presentation, please throw it up there. And we have also left a little time at the end to talk about that, but that's probably too much blathering for me. I'll just close my short open by introducing Eric, and once again, thank you all for joining. Interesting, very interesting. I hope you find this as interesting as we do. We're quite concerned and trying to figure out the impacts of the Cpra. But here, before I turn it over to Eric, I'd read a little bio for him. Eric is a professor of law at Santa Clara University School of Law and an Innovators Network Foundation Privacy Fellow. For those of you who don't know, the Innovators Network is an App Association Foundation arm that hosts fellowships on intellectual property, privacy, other topics, and we're very pleased. We're extremely happy to have Eric as a part of our privacy fellowship there. He co-directs the Santa Clara High Tech Law Institute and supervises the school's privacy law certificate. Eric teaches and publishes in the areas of internet law, intellectual property, and advertising and marketing law, and has been tracking closely and is a pretty well-known expert on both the Ccpa and the Cpra, and has a blog that's quite interesting. I'd recommend you read it, the Technology and Marketing Law blog. Eric, I hope I didn't go on too long there and flatter you too much, but thank you so much for being here, and please take it away.
Well, thank you, and I want to thank the ACT Association and the APP Association and Brian for their work preparing this event. And I want to thank all of you for joining us on a short week with holidays in the air to come talk about a tough topic. And I have a couple of disclaimers in advance. Disclaimer number one is you're probably not going to like much of what I say in this talk, and I can't really fix that. So don't shoot the messenger. Also, I know that many of you work in the health sector, and I endeavor to try to come up with a way of explaining in short, simple terms the interplay between the Ccpa and the Cpra and the federal privacy laws and the things that you're going to be dealing with on a day-to-day basis. And I'll confess, I gave up. It was too hard for me. I'm not a healthcare privacy expert specifically, and the interfaces between the federal law and the state law, I couldn't summarize them in an accurate and concise way. So I'm going to skirt away from some of the things that I know are top of your mind, and I apologize about that. They're totally relevant. They're just hard. And more generally, the Cpra, I'll do what I can with the questions. There's some I can definitely answer, and then there's some that are, the Cpra is so long, ponderous, and complex that it would actually literally require me to do research to come up with a confident answer. So we'll see where we go with this. But we are talking about a very, very complicated law. And so, you know, this is my first time speaking about it. I'll hear what's on your mind. But I am nervous that some of your questions are going to exceed what I feel confident about. But what I can do, and what I'm hoping to do in this talk, is talk about how we got here, what we have, and where I think we're likely to go. And that alone is a complicated enough story that it's going to fill up our time. And that's without doing a really deep dive on everything that's in the Cpra, because honestly, that doesn't fit in an hour-long format. So what I'm going to do, I'm going to share my screen here so we can follow along here. And on the here we go. On the November ballot in California, there were only two things I really cared about. There were a dozen propositions. We'll talk about that in a moment. There was, of course, lots of elections for political candidates. We obviously cared a lot about the president, but my vote didn't matter in California. As you may know, California voted over 5 million votes in favor of Biden. So any one vote in favor of Biden or Trump didn't really matter. And then there was Prop 24, the California Privacy Rights Act, which was a really bold move to take power away from the legislatures and put it in the hands of voters, a form of direct democracy. And I think a lot of what we're going to discuss today will depend on how you feel about that. Is that the height of democracy to have voters decide on an extraordinarily complicated law? Or is it the antithesis of our democracy, which is a representative democracy, where we elect representatives to be our smart agents when it comes to lawmaking, and we empower them to speak on our behalf, and many times to not say exactly what we want, but at least they're able to be active, smart participants in the system. And really the Cpra, more than anything else, as you're going to see, is a move to take power away from the legislature. And I don't know how you feel about it. So for me, and it was kind of the same kind of concerns I had about what was going on in Washington, D.C. I wanted to make sure that we had a robust, well-functioning democracy. And to me, the Prop 24 was not advancing that. It was conflicting with my view of what a well-functioning democracy does. So those were the two I cared about the most. Unfortunately, the CPRA passed, so here we are. So that's why I have the "this is mine" meme here. I know you all seen this many times over, but in some ways, this is really about burning down a representative democracy. And you have to decide how you feel about it, but I'm opposed to that. Okay, so I have, every time I talk about the existing law, the California Consumer Privacy Act, or CCPA, I've used this meme as a metaphor for the law. This is, of course, the infamous dumpster fire meme. And I adopted this meme from the very first time that the law was passed. And as I'm going to explain, the law was passed on a rush basis. And it was just riddled with typos, and it was filled with grammatical errors, and it had cross references that didn't work. It had sentence fragments. It was not only a bad substantive deal, but it was also just bad lawmaking. And so it really felt to me like an example of our governance system failing. And that's why I adopted the dumpster fire meme. This has become the image that I communicate every time I talk about the CCPA, and it's going to apply even more to the CPR. I don't know if there's like the dumpster fire version 2, the bigger dumpster fire. I would use that meme if I could adopt it. So I think this is really a good way of kind of visually communicating. These are laws that have some very structural challenges in them. And again, ask really powerful questions about how do we want to govern our country? How do we want to govern our state? What does democracy mean to us? And how does that translate when we're talking about building something as complicated and important as privacy law? So let me talk about the road to passage of the CPRA. And this is a story. You know, it's like I can't even get to the substance without telling you the story of the CPRA's passage. And it all starts in June of 2018, when a wealthy real estate developer in California, Alistair McTaggart, decided that he was uncomfortable with privacy regulations. I think his biggest objection was to data brokerage. He really didn't like the idea that people were out there selling data without supervision. But he had enough money and enough motivation to draft and qualify for the ballot, a ballot initiative that was going to be the California Consumer Privacy Act, the CCPA. So California has an open ballot, which means that if you can get the requisite number of signatures, I think it's 5% of the voting population, to agree to put something on the ballot is yours. It costs a couple of $1 million to do that, which is more than I can afford, but it's not out of the range for people who are generally pretty well off. It's kind of like a vanity project. It's like, hey, what have you done recently? Well, I have my island in the Bahamas that I own, and I also have this ballot initiative that I own. It's kind of a sport of kings type of thing. So we have an open ballot here in California. McTaggart was willing to pour the money in to draft a ballot initiative and then put it on the ballot. And he got the requisite number of signatures and he qualified it for the November 2018 ballot. And then he went to the California legislature and said, let's make a deal. I got a proposal for you. We can put this to the voters, and a lot of complicated things are going to happen at that point. Tens of millions of dollars are going to be spent in pro and con advocacy campaigns. And if the voters pass this law, because it's a ballot initiative, you're going to have very restricted ability to ever amend it in the future. So here's my deal to you. You can either roll the dice and let this ballot initiative go to the ballot. We'll see what happens. You're probably going to lose. Or you can pass a law that's substantially similar to my ballot initiative, in which case I'll withdraw it from the ballot, and then we will let the legislature run the CCPA going forward. You also have a voice as a legislature. So what's a legislature going to do when confronted with a deal like that? They're going to say, how dare you tell me how to do my job? On the other hand, you're threatening me with taking away my power. And that's an easy call for legislatures. If the choice is power or no power, they're going to pick the power. So the legislature said, okay, we'll play that game. We'll make a deal. And the number one descriptor during that period of time for the legislatures who were evaluating the CCPA is what they call the Hobson's choice, which As you may know, it's basically like you're damned if you do and damned if you don't. And that was basically the deal that McTaggart presented to the California legislature. And here was the catch. The ballot was going to be printed in 1 week. So it was, McTaggart said, okay, now that I've qualified for the ballot, you have 1 week to pass the CCPA to my specifications, or we'll put it to the ballot, we'll put it on the ballot, we'll let the voters decide. So the California legislature adopted the CCPA in a week. It's 10,000 words of incredibly complicated statute. It's those things where you read this, you're like, what are they talking about? I don't even understand how this works. That's why, as I mentioned, when I adopted the dumpster fire meme, it was filled with typos and grammar errors and sentence fragments and cross-reference mistakes and whatever, because of the fact that there were a bunch of hands that got into this ballot initiative, but they were all working on a rush job. Literally, the Assembly, the Senate, and the governor signed all within a week. So you can imagine what happens when you legislate in haste. You repent in leisure. So the California legislature adopted the CCPA with minor, but some very important changes. And so that was the deal. McTaggart said, here's the deal, you pass this, you can continue to supervise it. Now, guess what happens? By September 2019, a little bit over a year after the California legislature did exactly what McTaggart asked to do, he said, you know what? I actually really don't like the legislature having all this ability to supervise. I don't think they're doing a good job of managing my baby. So I'm going to do another ballot initiative. I'm going to go ahead and push forward with doing what I should have done the last time, which was taking power away from the legislature because I don't trust them. So by September 2019, he has introduced the Cpra, or what's now the Cpra. And the reason why the timing is so important is because the CCPA hadn't even become law. We literally hadn't even started with the law that he had passed, and he's already saying, you know what, let's burn it down, let's do it over my way. January 1, the law comes into effect. McTaggart's already working on the effort to tear it down and to rebuild it. And in June 2020, the California Attorney General, which had the power to make rules for the CCPA, finally finished its rulemaking process. So it took them about 2 years to do their rulemaking. Now, they actually didn't finish, and they've in fact started a new rulemaking of their final rules because it's a perpetual motion machine. Nevertheless, so we don't even have the full law in place until June of 2020. And the law becomes enforceable by its own terms on July 1. So no enforcement action has taken place until July 1 of this year. And then July 1, there were some letters sent. They were all done under the radar. There weren't official public releases of enforcement efforts. And there really haven't been since. California AG has been pretty quiet about its work, honestly, on the enforcement side. And then because of the late announcement of the rules, the full set of rules don't become effective until August 2020. So we finally had the CCPA fully in effect and enforceable August 20. November 3rd, California voters vote to tear down the CCPA, to end it, and to enact its replacement, the Cpra, McTaggart's second attempt at trying to dictate California privacy law. So you can see why I asked that question in the beginning, like, how do you define democracy? Here, the voters are asked to approve a law that was based on a law that was on the books for about 2 months before they're actually voting on whether or not to replace it. So if you think about the CCPA as an experiment, we didn't wait to get the results of the experiment before we deprecated it and moved on to the next version. And so you surely have a lot of questions. Well, did it even work? And if you codify in the Cpra and make it harder for the legislature to amend, what if you codified really bad, stupid things? And now we're back to the dumpster fire meme. Okay, the Cpra will become effective on January 1, 2023, and it will become enforceable July 1, 2023. So what I'm going to do is I'm going to first give you an overview of the CCPA, and then I'll show you some changes that the CPRA makes. So let's talk, I'm sorry. So the CPRA did pass, but let me just say a few words about that. So 56% of voters voted yes, about 5 out of 9, which is actually pretty good by proposition standards. California voters are sick of the open ballot. So many voters just vote no on all of them. They just, you start out with a deficit of votes if you're the proponent, because voters are sick of this entire process. So getting a 5 out of 9 is actually pretty good by proposition standards. However, it's not a slam dunk. It's not like this was something people were really excited about. And in fact, the McTaggart's group released polls at the beginning of the election cycle that suggested that they thought they were going to get more like 75% plus of the vote. So to come in at 56% is actually probably pretty disappointing for them. They'll take the win, no doubt, but they're probably pretty disappointed because they thought they were going to crush it, and they didn't really crush it. And one of the reasons, the way they got to 56%, there was $6 million spent on the pro side. 99% of those dollars came from McTaggart. This is a vanity project of McTaggart. The support for it was actually pretty thin. You had to work really hard to find someone who understood privacy law who actually supported it. There were a few, but there weren't actually that many because of the fact that most people saw it and said, oh my God, what is that? The no votes was $52,000. Okay, now here's something that blows my mind. And for all you in DC, you're saying, well, surely the business community rallied against this law because it's such a terrible law. No, they didn't. Everyone stood on the sidelines. They literally did nothing. That $52,000 came from some public advocacy groups that are actually pro-privacy, but anti-CPRA. The business community did nothing on this one. Now, you may also know that in the same election on November 3rd, Lyft and Uber were able to pass an amendment to an employment law that allows them to have a special characterization for their drivers as gig economy workers. They spent $200 million on that law and got it to vote yes. Now, what would have happened if the business community had thrown $200 million at this law in order to scuttle it? Could they have swayed 6% of the voters to go from yes to no? It seems to me that that could have been done. Instead, $52,000 was spent. So literally McTaggart waltzed to the finish line with no real opposition. Now, anyone who read the law is like, what is this garbage? And I hope you can't hear. We've had the gardeners here today, and I'm thankful for their work. The guy is now blowing the leaves about 6 feet away from me. So I'm sorry for any noise. I'll see if we can get past this shortly. Okay, so for the people who actually read the bill and opined upon it, they were overwhelmingly no. A couple of editorial boards of newspapers came out in favor of the law. All the rest of them said, what is this garbage? And I think that's one of the reasons why the vote was as relatively close as it was, because so many newspapers were like, this is not a good law, guys. If you're expecting to vote no on all propositions, this is a good reason why you should continue that practice. I helped organize a petition that was pretty simple. It just basically said, I'm a privacy expert and I think that this law is terrible. Vote no. Even though if it passes, I'm going to make a lot of money. And this law is great news for the students that are on privacy law certificate. They're going to make a ton of money from this law. But a number of privacy experts are like, I don't want that money. There's going to be enough money to be made on the CCPA that's already a dumpster fire. We don't need to pour gasoline on that dumpster fire. And so a lot of the people who looked at this law said, this is a terrible law, but it was a pro-privacy law in an era when people want more privacy. There's no money being spent in opposition of it. And so, of course, it's going to pass. It's not really even a close question, is it? Okay, let me do the baseline of what the CCPA said. So this is what the law is today and what the law will be through the end of 2022. And then, as Brian mentioned at the introduction, we're going to talk about how the CPRA extends and modifies that. Okay, so let's talk about the CCPA. So the CCPA applies to for-profit businesses. It doesn't apply to nonprofits. It doesn't apply to the government, who have either $25 million plus in annual revenues, or who make 50% or more of their revenues from data brokerage, or from people, from businesses that collect personal information from 50,000 or more individual consumers in a year. And this is the basic framework for the CPRA, with one exception. The number 50,000 got boosted to 100,000. So there's going to be some entities that were covered by the CCPA that will drop off because of the CPRA's higher standards. Okay, so we've got this, the standard here for who it governs. It basically covers the California business economy. And studies have shown that it covers hundreds of thousands of businesses in California. And then, of course, there's businesses who aren't located in California, but might nevertheless be doing business in California. They're also likely to be covered by this law as long as they meet one of these thresholds. And meeting these thresholds is trivial for any mid-sized business is likely going to trigger one or more of these requirements. Okay, so hundreds of thousands of businesses are currently being governed by the CCPA because they meet one or more of the standards. Now, the CCPA has a provision that tries to harmonize its coverage with HIPAA. However, it doesn't quite work exactly like that. What it basically does is, so there's certain categories of HIPAA governed information that we won't touch because they're governed by HIPAA. So it's a toggle, but the toggle is based on the data, not necessarily based on the entity. And so that's about as far as I'm going to take you on that question. And that's why in practice, many HIPAA regulated entities are going to have CCPA governed data because of the fact that they have data that's outside the scope of HIPAA or outside the scope of the particular protected classes of data. Pretty much any healthcare organization that is in California doing business and triggers one of the other thresholds is likely to care about the CCPA and actually potentially care quite a bit, because it's possible that a fair amount of the economic value of that organization actually is going to come from from data that's going to be governed by the CCPA. Okay. So the CCPA says for these regulated entities, the consumers get a bunch of rights. And these rights are enforced only by the Attorney General's office. There's no private right of action for them. At least so far, plaintiffs are trying. I don't think they're going to succeed. Any of the businesses covered by CCPA have to do the following. They have to provide consumers with a right to know about them. That includes things like disclosures that are prescribed by the statute and by the AG rulemaking. Here's what you got to tell people. And there's a whole bunch of rules about that. And then you have to tell people what you know about them. You have to let them see what information that you have about them, and you have to give them the right to delete that information. There are some limits on what deletion rights are available, but in general, the idea is if you have information that's personal information about the consumers, they need to be able to see it, they need to be able to delete it, in addition to the more generalized disclosures about business practices. They're also supposed to get the right to download that data so they can take it to a competitor or keep it for their own purposes. So there's, I call it the right to port. There are other terms for this, but the idea is that they should be, it's a data portability enablement. Consumers are supposed to be able to get their data so they can move it somewhere else. Consumers have the right to opt out of data sales. So the idea is that if businesses are selling data, then consumers can say, I don't want to do that. And if it's dealing with data about minors, then the minors actually may have to opt into that data sale. They're not governed by the opt-out. The definition of data sale and the statute is broader than you might think. It's not just straight cash for data. Other forms of data transfers could qualify as a data sale. And the CPRA is actually going to extend that to basically say there's this concept of data sharing, and we're going to govern data sharing as well. So even if there's really no clear quid pro quo, there's still going to be potential limits on the movement of data. And then businesses are not allowed to discriminate against consumers because they exercise their privacy rights. Now, this has been a pretty confusing provision, and I don't think we understand it even today. One way of reading it was a wide scale anti-price discrimination statute. Pretty much any way in which you wanted to do price discrimination among your consumer base would be based on some way of them exercising the privacy right and therefore be triggered. So this reached potentially things like loyalty programs, which got a lot of attention from businesses because they engage in loyalty programs all the time, and they want to segment their high value customers and give them extra love to try and reward them for their loyalty. And it's not clear what if that is even still permissible today. That remains an active area of consideration. But certainly things like if someone says, I want to delete certain data from my account, I'm exercising my right to delete, you can't then subject them to less favorable treatment or higher prices in that circumstance, unless you can justify why you're doing that. And so there's very complicated rules about how you would justify that. Okay, so there's 5 consumer rights that the Cpa creates, and then there's a 6th right that they create, which is a private right of action for certain data breaches. Basically, the idea is that the statute wants businesses to encrypt their data or to otherwise make it so that even if someone were to get the data, they couldn't use it. And so if the data is not properly protected and it's breached, then there's a private right of action. And we've seen dozens of class action lawsuits filed since the law became effective, suing over data breaches involving California consumers using this provision. So we would expect this to be an active area of litigation for the foreseeable future. Okay, then the law delegated a bunch of topics to the California AG's office to make rules about. So there were certain questions that were either too hard for the statute to address, or that were likely to evolve over time, and in that evolution, they wanted to have an administrative agency supervising the question. So the AG's office has released another 12,000 plus worth of rules. So there was 10,000 words in the Ccpa, another 12,000 plus of words of rules. So we've got about 20,000 words of statute overall nowadays under the Ccpa. And there's a lot going on in those 12,000 words. I could not possibly do justice to all of them, but I want to highlight just 2 things that have emerged where I really think that the AG's office basically took on the role of legislation and adopted things that weren't into legislation but still have substantial bite. So the first thing that they adopted is that businesses are required to honor an opt-out. To honor an opt-out that's communicated by a browser. They call it a global privacy control in the statute. And they created this thing that doesn't exist in the field today. And they said, if there were such a thing that allowed consumers to say, please don't sell my data, then businesses would be required to honor that signal from the browser and not go through the other opt-outs that were described above. So, you know, on the one hand, you could say, isn't that great? They're creating this mechanism for businesses to more efficiently handle opt-outs. Or you could say, what is this? The AG's office contemplated this emergence of technology that doesn't exist today, and they mandated compliance with the technology that nobody even knows exactly what that will look like in the end. So again, you can decide how you feel about that as a form of democracy. Do we want the AG's office manufacturing compliance with technology that doesn't literally exist when the AG is making its rules? The other thing that they did I thought was very interesting is they created a mandatory transparency report for large businesses. Businesses that have over 4 million of California consumers' information in their databases are required to basically tell a bunch of data about how the rights are going up above, these rights to delete or the right to access. What kinds of experiences are they having? And they just made that up again. There was nothing in the statute that suggested that that would be necessary. The AG's office basically said, we'd like to know more about what's going on in the field, so why don't you tell us? Of course, no, without really caring that it was going to pose substantial compliance costs on the businesses that have to produce that report. Okay, so that's a very quick overview of the CCPA. And the general idea beyond the CPRA is that it took the CPA and it cloned and revised it, which I know we're all familiar with in our practice. So you know kind of what happened. They took it and then they amended it. So it has the same bones as the CCPA, but the amendments were extensive. There is a lot going on in the CPRA. And the most important thing to contextualize that is, I haven't been able to get a precise count because of the way that the documents are. I think it's about 27,000 words. Please don't quote me on that, but you get the idea. So it's taking this 10,000 words plus some of the 12,000 words from the HE rules, and it's reduced this 27,000 word or something like that monstrosity. And one of the things I asked people to do before they voted on the laws, I said, just try and read the first 5 pages. Just do that. You don't have to read all 52 pages, just try the first 5. Because I was confident that anyone who tries to read this would stop and say, I cannot support this law. This law is drafted the most Byzantine, arcane, counterintuitive, elliptical way possible. No one who reads this could say this is a good idea. I was so confident. All you had to do, just take a taste of it. And if you took a taste of it, you're like, never again. I don't ever want to deal with that. And so that's one of the reasons I told you I might set some limits on how I answer the question, because there's so much going on in this. There's so much complexity to this law. There's so many elliptical loops between them. You know what I mean? Like, you know, when you're computer programming and you got your nested loops or whatever, there's nested loops and nested loops and nested loops in this bill. It's just, it would take a lifetime to try to master. It might take multiple lifetimes, honestly. There's so much complexity to it. Okay, so let me highlight some of the more important things that have come from it. So the bill creates some new consumer rights. In addition to the 5 that I mentioned before, the 6, including the data breach, private right of action, there's a right to correct the data. So you have the right to access it, you have the right to delete it. Now you're going to have the right to correct the data. There's a right to restrict how businesses engage with sensitive personal information. So it creates this new category of personal information called sensitive personal information, and it gives consumers greater toggles over what can happen with that sensitive information. Now, for your purposes here, I'm pretty sure that anything that you would think of as health or biometric information is going to be covered. There's really broad definitions of health information and broad definitions of biometric information, and they're defined as sensitive information. So this right to restrict how businesses engage with sensitive information is definitely going to impact the healthcare community quite a bit. Again, I'm only going to take you that far. The rest of it, we're going to have to get the healthcare privacy experts in. And it gives consumers the right to opt out of data sharing of personal information, not just data sales, but it's going to create this extra concept that even in circumstances where there's not an express quid pro quo data for cash, that consumers are going to have toggles over their willingness to share their data. There's a bunch of new obligations on business in addition to the new consumer rights. So for example, there's going to be a business-wide obligation to deploy reasonable security. So there were some limited security rights like the data breach requirements in the Ccpa. This is going to blow it out and basically say businesses have an obligation to comply with reasonable security. The Cpra creates a new data protection authority called the California Privacy Protection Act, or the Cppa. So we got the Ccpa, the old bill, we got the Cpra, which is the new bill, and we got the Cppa, which is the new enforcement agency that the bill creates. So we got acronyms galore, and you got to be really precise with your enunciation to make sure you're clear on which one. Now, as a conceptual matter, many of you might actually think a DPA could be a good thing. DPAs have lots of challenges in foreign countries. We know that dealing with them is never a joy. But on the other hand, they generally understand that privacy is a trade-off, a set of balances. And so DPAs, especially in Europe, are well known for being open to discussion or negotiation or considerations beyond the literal letter of the law. Say, look, we're trying really hard, we're doing our best, will you work with us to try and come up with a reasonable outcome? The current Cpa is enforced by the AG's office, and they're litigators. That's all they do. So they're not really in the mood to play ball with anybody. They just want us to. So the idea of taking some of the enforcement authority out of the AG's office and putting it into this new DPA-style entity could potentially lead to taking things away from litigation first mindset into a more, let's try and manage privacy holistically type mindset. That could have been a good thing. Sadly, the DPA structure is completely whacked. And so it's going to have an enforcement first mindset, and it's going to view businesses as the enemy. And this is both in terms of the little instructions that are provided to the DPA, as well as the kind of people who are likely to join the DPA and the the organizational culture that they're going to develop. So we have this new privacy cop that's going to be coming on the beat, but they're not going to be coming on the way that you think of a DPA. They're going to be coming on with a how do we crack skulls type mentality, not dissimilar to what we would have expected from the AG. Now, the AG retains some enforcement authority as well. So now you're going to have two privacy cops on the beat, and each of them is going to be looking to outdo each other. So we're going to have a lot of potential privacy enforcement coming from these two entities. And it's not the way that you would have hoped with a DPA. Now, furthermore, the DPA is going to create some new administrative enforcement mechanisms. Basically, if the DPA launches an enforcement action, it goes through the DPA's adjudicative function before it goes to court. Basically, they say you violated our administrative rules, and therefore you need to explain your practices. And then there's a review and appellate process within the DPA, and only at the end of that will those matters go to court. And when they go to court, I'm not an expert in administrative law, but I believe that the DPA's conclusions will have some persuasive effect on what the court can then do. So the DPA is going to have a thumb on the scale. Whatever they decide is going to make it harder for businesses to litigate it in court once it reaches that stage. Now, that entire process, you should note, is going to likely double the cost of any defense. If some business thinks they have a meritorious defense, they're going to have to exhaust the DPA mechanisms and then go to court and then do it all over again. Again, you've got this great idea of a DPA, but the way it's structured, it's actually likely to make businesses more likely to settle with the DPA because of the fact that it's going to basically cost them twice as much to defend their rights. Okay, the Cpra, it said, we know that there's a bunch of things that need rulemaking, so we're going to delegate those to the DPA. There's 22 topics, which is substantially more than the Ccpa. So all that 2 years of madness that we went through with the Ccpa rulemaking, we're going to do all of that and much more with the Cpra. It's going to be a rulemaking palooza. And again, this is great news for anyone who's a lawyer who's going to be advocating for particular rules for their clients. Cha-ching. But for everyone else, this is going to be an overwhelming process to try and keep up with, manage, and understand the consequences of the rules. Remember, we've got this already 20 some odd thousand word statute. It's going to be supplemented with, I'm guessing it's going to be 20,000 plus more words of rulemaking, or at least maybe far more than that. So we're just going to have this massive dump of code onto the California economy. The Cpra comes in with all these rules, and then the rulemaking comes in with a whole bunch more. It's going to be a lot to digest. And it's going to be out of the realm of an average business to try and understand on their own. They'll have to hire a lawyer. And I think what's going to happen is that many privacy lawyers who try to have a national practice are say, you know what, I can't keep up with that 40,000 plus words of code. That's too much. And then, of course, that code is going to be supplemented by DPA rulemaking, by DPA enforcement. So we're going to get new adjudications coming from the DPA. And anyone who wants to understand law is going to be keeping up with that. It's going to require Cpra specialists, not privacy specialists, but Cpra specialists to try and keep up with this law. Okay, and then the last thing I wanted to introduce the Cpra is to talk about its amendments. So as I mentioned, the Cpra's payload is to take power away from the legislature and restrict the legislature's ability to amend it. Now, the Cpra says that the legislature can amend the statute. It gives the express authority to the legislature, but only in a way that's consistent with the act in total. And here's the provision that I think is really the dispositive provision on the amendment. It says, quote, the law should be amended if necessary to improve its operation, provided that the amendments do not compromise or weaken consumer privacy while giving attention to the impact on business and innovation. So this law, the amendment process is designed as a one-way ratchet. A legislature can make the law more privacy protective, but can't make it less. That's not on the table. And what it also means that the legislature can't do is just say, you know what, we want to adopt a different paradigm for privacy. The legislature can't do that because undoubtedly adopting a different paradigm for privacy would weaken or compromise, at least in some ways or some places, consumer privacy. So we're stuck with the basic structure of the CPRA. That cannot be amended except by another ballot proposition. And I don't think that we can see even anything that might be neutral with respect to amendments. I don't think the legislature has that power. They can only do something that does not compromise or weaken consumer privacy. But they also have to give attention to the impact on business innovation, which means that the business and innovation community can come and say, you know what, that amendment, you didn't properly consider our interests when you adopted it. So no matter what happens here, if the legislature decides to amend the CPRA, it could get sued by one side, the pro-privacy side saying you compromised or weakened my rights, or the business side saying you didn't give adequate consideration to the impacts on us or innovation, or both. It's possible that both sides would litigate against a particular provision. So what's going to happen with the legislature knowing that everything that they do to touch this law is likely to trigger a lawsuit? They're not going to touch it. They're going to stay away from it and say, you know what? I don't have time to go and pass something through the legislature only to see it go to court and 5 years from now fail. I got better things to do with my time. Here in California, legislators are term limited. You only get 2 terms. So you got to make that count. You're not going to want to take your potential 8 years and waste it trying to address this only to know that it's going to create a litigation that you might not win. So I think the CPRA is just going to basically remain a fossil of the past. I think it's going to stay pretty much the way it is. The rulemaking might change it, the DPA enforcement might change it, but the legislature ain't going to touch it. Okay, my last slide. Let's just talk about what might happen in the future. And then we'll take whatever questions you guys have, and then we'll take our break and start thinking about Thanksgiving. So what's going to happen in the future? Do you think that this is the last time McTaggart is going to go and adopt a ballot proposition to govern privacy? And I'm sorry, I think you need to hear in your voice, ha! I think that's the best way of thinking about it. Of course, he's not going to stop here. He's already had 2 successes. Why would he stop? The only thing that's going to limit him is if he doesn't want to spend his money that way. But if he's got the money and he's got the will, why wouldn't he go back to the well again? So we're not done with this process. We continue to be in the hands of McTaggart deciding what he thinks we ought to do for privacy. Will there be litigation challenges against the CPRA? Ha! Why do I think that? Well, because there have been no litigation challenges against the Ccpa, of which the CPRA is based, and because businesses weren't even going to spend money trying to defeat the law. Why are they now going to spend the money to go to court? They had their chance at the ballot. They didn't spend a dime. They didn't even try. So will they try now? I don't see it. I don't think so. And I know that some litigators will beat their chests and say, oh yeah, I think I can beat this. Until we have a paying client who's willing to put their name on a lawsuit that will be viewed as anti-privacy, I don't believe it. Will the legislature superintend the law? Ha! They have the right to do so, but I don't think there's any chance they will. One of the sales points for the CPRA was that it was going to be very GDPR-like, and that meant that we could possibly overcome problems that we have with movements between California and the EU with things like the safe harbor and privacy shield failing. One possibility is that maybe California could go get an adequacy decision. Will we be able to get an adequacy decision? Ha! I think that's just a pipe dream. I don't even know why anyone would say that. I think the bill moves closer to the GDPR, but I just don't see how we're going to possibly say it's close enough that it enables an adequate decision. At its core, much of the GDPR is like a regulatory control of privacy. While still there's a general opt-out model that's built into the CPRA. And you just can't reconcile the two. I don't see how you possibly could. Okay, so I don't see any of that happening. What I do know is that businesses are going to have to redo their privacy program again. So even if they did full compliance with the CCPA and full compliance with GDPR, there's enough differences in the CPRA, they're going to have to redo that. Now, they don't have to start from scratch, but they're going to have to redo the work. And so this is really unhappy news for businesses that have been walloped by the shutdown, that have been walloped by the pandemic, that are literally not able to make payroll. These businesses are now being said, oh, and by the way, now whatever money you send CCPA, thank you, you got to spend some more money. a real unhappy payload for the California economy. I've already mentioned, I think there will be the emergence of Cpra specialists, and I think that many general privacy lawyers are not going to be willing to advise on the interstices of Cpra. I just don't think they will be able to keep up. There's just too much law in the rest of the globe that they're needing to track that they won't be able to manage the details here. We're going to have a massive rulemaking, and if any one of you is able to find a client willing to pay you to do this work, go ahead and get your kids into private school, because you're going to be able to make that tuition no problem. That's due on July 1, 2022. We'll see if that's realistic. It took the AJ's office 2 years to do the Ccpa rulemaking, and they didn't have as many things to work on. So I don't know if they're going to be able to get it done in 18 months. If they are, it's going to be a very busy time. Will other states adopt the Cpra? I know there are some that want to adopt the Ccpa, in which case it would have been California saying, go ahead and copy us. Ha! Fooled ya! We're actually going to do something different. I don't think we're done here in California. So anyone who adopts Cpra, we're going to do the same, Lucy and Charlie Brown in the football. So I think that the adoption by other states is possible. The moment another state does anything quite like what we're doing, we will absolutely have a dormant commerce clause problem. There's no way that we're going to reach the same conclusions. And if we don't, then businesses working across borders are going to have some real sticky challenges trying to manage 2 or more different privacy compliance programs. Okay, and then the last question is, when are we going to get a federal law? And when do we get a federal preemptive law? And this is more on you than it is on me. If we don't get the federal preemptive law, we got all these terrible things coming for us. We got this dumpster fire of a law that's going to be governing the 40 million Californians. And that can't be the right outcome. And a federal non-preemptive law, that only makes things worse. That doesn't solve the problem. So the solution to the McTaggart multi-iteration game in privacy law development in California, the solution to passing a law that really creates structural problems for the entire economy in California is a federal preemptive law. And here's the only slight glimmer of good news. Because the law passed only 56%, it wasn't like the California voters gave a ringing endorsement of Cpra. Obviously, they endorsed enough to pass it, and that will become part of the conversation. I think there's room for a federal preemptive law to say, we're not going to take the Cpra model. We're still going to protect consumers, but we're not going to follow that faithfully. And I still think there might be room for that. But boy, we need it. And saying that the Cpra starts January 1, 2023, so that's the deadline, totally misses the point. Businesses are going to spend billions of dollars in compliance work well before that. So if we wanted to avoid all those potentially wasted costs, the time is now. And unfortunately, I don't think Congress's will is now. So the more likely scenario is we're going to have a few years of Cpra and all the joys that brings before Congress decides enough is enough. All right, I've been yapping away for quite some time here. Let me take a break. I think we're probably ready for some questions.
Thanks, Eric. That was great. Great. Really appreciate it. One question someone's asked in the chat and in the Q&A, folks are wondering if we can distribute your slides.
Yes, absolutely. And I will send them to Brian after this. I will also post them on my Twitter feed, which you're welcome to follow at Eric Goldman. So yes, these slides will be freely available for you soon.
Thank you. Wonderful. Okay, so I actually had one question that someone has asked here in the Q&A that kind of is a mix of something that I was thinking about. So I'll try and put them together. But thinking about, where practically how folks are going to find themselves in a comfortable place as far as compliance when they need to be there, is the idea. So somebody asks here, how should an ideal DPA be designed to enforce the Cpra? And what I had thought in my head was, I was like, do you see like the practical, some people roll their eyes at the idea of like yet another certification, from some third party. But it can be a means of, I guess, some assurance of a compliance, or maybe even a safe harbor? But is this new California DPA? So I'm more specific than the question in the Q&A, but how can this DPA function well, do you think? And do you see that as like, is that kind of where we might end up, is somebody like, I don't know, IAPP does it for professionals, not for organizations, right? But some trust arc or something like that is going to step in and come up with a, and then with a certificate I can get with a gold star and put on my wall or something like that. And everyone's it's just going to become like a cost of doing business. Is a certification of some kind as a means of compliance, maybe the practically an end game, and the pros and cons of that. But is there a chance that such a certification could be, anointed as a safe harbor by this new DPA?
So there's a lot going on there. Let me start with one thing that came up in the Ccpa, which was, could there have been some kind of safe harbor for businesses that could demonstrate that they were GDPR compliant? Could they then use that certification and say, okay, we've met the requirements of Ccpa and more, therefore we shouldn't have to invest in 2 different compliance programs. Let us just do the GDPR standard. And the California AG's office expressly rejected that and said, you know what, the laws are so structurally different that we don't think that you being GDPR compliant is good enough to meet all the requirements of CCPA. Therefore, you have to do both. If the law doesn't permit that kind of approach, it doesn't really matter. Certifications are a great way of taking the first cut of enforcement out of the hands of government officials and putting it in the hands of private entities. They have other problems, like the fact that the private certifiers are often willing to play ball in ways that the government agencies aren't, because they want the money. You can't really fix that. It's kind of moot, though, to ask about whether certification would have worked here, or it's also moot to say what would an ideal DPA look like, because the legislature can't amend that. It's almost certain that the legislature couldn't create a certification process, or that they could reconfigure the DPA under the existing amendment process. So we could talk about what we would have liked, but the CPRA's biggest payload is its hindrance of the legislative function to answer questions like this. And so to me, I'm happy to speculate them, but I do want to note that it doesn't really change how we feel about it. Now, one other thing on certification, I think there will be the emergence of a number of businesses that will try to automate compliance with pieces of the CPRA. That's already happening with the CCPA. For example, there's a number of businesses that are trying to automate DSAR requests, so that they're taking out hands of businesses having to home brew a way to give access rights and letting it be handled by these third-party vendors. And I think all of that's terrific. The question, of course, is, does that actually then confirm compliance with law, or is it simply that you have to do that, but you still might be out of compliance, and so what? And now the gardener is gone, but the cat has arrived. So if you see a kitty, this is Kitty Nala. And with the emergence of either certification processes or with privacy technology vendors, those impose additional costs that we can really quite clearly quantify. Those are now straight out-of-pocket costs to the businesses. So those become all part of the overhead of doing business here in California that we'll be able to model and state. Now, if that ends up being less than the homebrew compliance, that might actually be a net win. But notice that no matter what, those are still increased costs, whether they're homebrewed or outsourced to a vendor. We're still seeing jacked up costs. Now, in terms of what would have made a better DPA, I don't have really hard and fast thoughts about that. But I do question the idea of the DPA being both the rulemaker and having its own administrative enforcement process. I think that there's the potential for some conflicts of interest there. Or more importantly, I think that it's going to create a enforcement first mindset, because so much of the action is going to be, so much of the the investment of the organization is going to be in the administrative process to adjudicate cases. So I probably would have cut that out of the DPA's portfolio. And I also would have written the DPA's instructions to be a little bit more accommodative of the balance. It's written into the charter of the DPA that privacy is a fundamental consumer right. Now, when you have that in the charter, you kind of trump the opportunity to do some kind of balancing act between business interests, consumer interests, and third-party interests. You make the consumer interest paramount and put everything else on second tier. So it's stuff like that in the charter that I would not have done. I would have written it very differently to try to reinforce that privacy is a balance. And the Cpra didn't do that, and it cannot because that amendment would not be possible.
Got it. Thanks. And I realize, folks, we're just a couple minutes over. I don't know, Eric, if do you have a couple of minutes?
I do have a few more moments, so I'm happy to keep going. And I apologize I took as long as I did with the set remarks.
No, no, don't worry. Here's one I can just read. So will patients be able to alter or remove their data in electronic medical records with this law?
And I'm going to declare that's out of bounds for my expertise. My hypothesis going into the research would be the answer is no, because deletion rights are not absolute. And so there's some restrictions on it. And to the extent that the EMRs are the data that's not governed at all by the law, then they also wouldn't be governed by anything like the access rights either. But those access rights might be provided by HIPAA. So it's really a question, does HIPAA govern it, or does the Ccpa govern it, or the Cpra govern it? And so that toggling of where that frontier is, that's the question I would want answered. My hypothesis would be that those would be governed by HIPAA and not by Cpra. Please do your own research on that.
Great. Let's see here. Here's another one I can read. Is it true that cure, quote unquote, is only allowed for data breach missteps, unlike the CCPA's broad allowance for cures before penalties?
I believe that is accurate, but again, I need to research that one. My understanding about that is that the entire notion of the cure period is going out of the AG's enforcement rights. So I think that we're going to see a step back on the cure process. Now, of course, one of the questions will be what the DPA does in interacting with businesses. It's possible that they will still view it as an opportunity for them to reach out and try to work things out without launching a formal enforcement process. So it's not clear to me that that in practice we'll see a difference, but I believe that the AG's cure period is being curtailed.
Okay, well, there was one more question in the queue that I think just kind of you sort of have answered across this Q&A discussion and before that, so I marked that as answered, but I didn't have any other more questions there. One other one though that was on my mind I was thinking about was because, and especially because the GDPR came up, I thought about this, was around as in the context of GDPR in Europe, as the European Data Protection Board has issued recommendations and DPAs are evaluating, you know, and enforcing and things like that. One development that has come up for folks who are working on AI solutions has been a statement from the European Data Protection Board that all the purposes that one is processing data for must be listed, and it has to be in an exhaustive list. And some people have complained and said that will inhibit new and innovative uses of AI tools. And I wondered if there is there a similar requirement in the Cpa, Cpra about disclosure of processing purposes, and is there a similar dynamic going on in California with California's new law there? Also, I wonder if you think that that's a legitimate complaint.
So I need to take a look at that question. I mentioned that's one of those things where there's going to be all those nested loops. There's a number of discussions in the Cpra about making inferences about consumers, so stuff that could very well cover things like AI or machine learning. And then I'd have to trace to see where the disclosure requirements would pick that up. So it is possible that something similar would be required by the law, but I'd have to verify that. Okay. In terms of how we'd like to proceed, I mean, I think we just have this threshold question. What does privacy mean to people? And when machines are going out and doing their thing to try and help businesses figure out better ways of serving their customers, or making business judgments at a macro level, not on an individual level, who cares? And I think some privacy folks do, and I think that many people would say it's just no big deal. But certainly things like the Cpra can reach very deeply into these processes. The definition of personal information is so broad, and the ways in which data is manipulated are so numerous that Cpra can interfere with, I think, a lot of things that we just assume we can do today. So I don't know what we're going to do about that. To what extent that's going to simply be solvable through some kind of notice and choice type model. Tell it in your disclosures and let consumers opt out of that if they have the right to do so. Or to what extent it's going to become more like this: you can't discriminate against consumers for exercising their privacy rights, and all of a sudden now you literally cannot clearly run loyalty programs without figuring out how to check off all the right boxes. So to me, I think that's really the threshold question that we have here. Is, you know, what do we want from a privacy law, and what do we want from a federal privacy law, hopefully preemptive, that cleans out laws like this? What do we want in terms of things like making inferences by computer, whatever that means? And I think that that's a conversation that I'm not sure we're really well informed enough to have, because I think there's just a lot of fear mania about that. I think a lot of people are just really afraid the machines are coming to kill us, and anything that a machine ever does will be done to my detriment. And until we get over that, I think we're going to have very difficult conversations.
Yeah. Well, I realize we've taken people. Thank you for staying a little late here. And for folks for hanging on. By the way, Eric, we had an incredible attrition rate here. We basically had 0 people leave this webinar for 1 hour. So that's
well. Thank you all for sticking around. You definitely got an earful.
Yeah, that says a lot. Thank you for this great update here. I think it's just you know, it's great information, a great baseline. And for being able to share your slides, I think that's a resource that a lot of people will rely on, and you know, this has been pretty ideal in getting people up to speed, and hopefully you're seeing some of the good feedback there in the chat too. You know, for the Connected Health Initiative, thank you again for being a part of this and getting and helping educate the community here. It's really important. So.
Well, thanks so much for organizing this. And again, thank you to everyone for sticking around during a holiday week. I wish I had better news, but at least I hope you you know where the state of play, and now we figure out how to make the best of it.
Absolutely. All right. Well, that'll probably do it. I'll end the webinar here in a second. Thanks all, and have a happy Thanksgiving.